All right. Okay, we are now live. So this is Chris Berry with Castle Wealth Group, certified financial planner, certified law attorney with Castle Wealth Group. And we do these weekly wisdom webinars every week at 1 p.m. And we have them scheduled throughout the year now. Occasionally you can't make it because of a prior commitment or traveling or a holiday, but we do try to do these every week. And each week we start with a positive focus, something positive that happens. And really the purpose of these webinars is just to answer questions, questions that people submit throughout the week or questions that people have on the webinar. So it's not like a prepared presentation. There's no PowerPoint or anything typically. It's really just going ahead and talking about either what's happening in the world or answering any of your legal, financial, or tax questions. So with that, if you do have anything that's floating around in your head, feel free to put it in the Q&A. And I'll go ahead and address it. I already have one that just came in just now, so I appreciate that. But I'll start with that positive focus. Positive focus, I got back from a continuing education workshop. So as a certified law attorney and certified financial planner, each year I have to get maybe 30 hours of continued education in. And that's something to maintain my designations. As a financial planner or attorney, really there isn't much required in terms of continued education, which is kind of scary. Even on the legal side, I think like hairdressers, no offense to them, have more continued education requirements than attorneys. Attorneys actually have zero continued education requirements, which is kind of scary when you think about it. So, but as a certified financial planner, certified law attorney, we have to be peer reviewed and we have to show that we have enough approved continued education each year. And so I was just reapproved as a certified law attorney. And now I will have been one for 15 years. So I had to submit that over the last 5 years, just on the legal side, that I had 80 hours of continued education. So it's always sharpening the saw. And I just got back from one. And it was Ed Slott's IRA leadership. And this was the workbook, and this is all on IRA rules. It was pretty in depth. And I don't know if you've heard of Ed Slott. He's been on PBS. He's thought of as America's CPA. But I just got back from it, and I've been part of his program for a number of years, but it's crazy. So this is just on IRAs. It's 191 pages. So 191 pages. It's basically like going back to law school again. But it's always good to stay on top of things. And so it's good to get away for a couple days and good to be back. And really it's just to best serve our clients. And that's one thing that when people attend our workshops or sit down with us, sometimes they hear some strategies that maybe they haven't heard of before or they need some clarifications. Well, it's because I go to continuing education, learning from the best and the brightest, trying to stay on top of things. So that's my positive focus. And with that, I'm going to go ahead and at least try to share my screen. Let's see how technology works. Zoom is always like updating and make me download a new plugin or something every time. All right, so that button, and now it should be, let's see, come on. There we go. Only took like 5 times. Oh, technology is great, except for when it doesn't work. And if someone could put in either the chat or the Q&A, make sure that you can see my screen. Should be saying weekly wisdom webinars. If someone could just verify for me, just one person, if you could, into the chat, say, Chris, we can see it. Sometimes Zoom changes things on me. All right, looks like we're good to go. Okay, cool. So with that, let's go ahead and get into things. So the first question, how can my father pass the house to us without having to pay capital gains tax? So we have real estate. So we have a house. And the question is, okay, upon death, let's say we bought the house for $100,000, okay? Number of years go by, and now upon death, let's say it's valued at 300,000. And then let's say the kids sell maybe a year later, and it's valued at 350,000. So the question is, what would be the tax consequences of this? And so the thought some people have is, well, if you bought it for 100 and then you sell it for 350, there's going to be $250,000 worth of capital gains. But that's not the case. Because what happens is there's a step up in basis upon death for real estate and non-qualified assets. So when someone passes away, the new basis for any type of gains is going to be the fair market value at date of death. And so if the fair market value at date of death is 300,000, that's the new basis. And so now the capital gains that could be owed for the kids would only be capital gains on the $50,000. And again, it's not income. This would just typically be capital gains. And to clarify, we need to make sure that we pass the house or any real estate correctly through this process. So there's different ways to pass assets. One would be like adding a child joint to an asset. Another would be through a beneficiary designation, passing the house. Technically, designation. We call these ladybird deeds in Michigan, where it's in mom and dad's name during their lifetime, but then upon death, it goes to whoever's listed as a beneficiary. We call these ladybird deeds. Another name, the technical name is enhanced life estate deeds, but just in Michigan, we call them ladybird deeds, named after Lady Bird Johnson. And then the third way to pass assets would be through a trust. But if an asset doesn't pass through one of the first three, then it ends up going into probate. Okay. Everyone wants to avoid probate, so we don't want to rely on that as a way to transfer assets. But if it does go through probate, you do get step up. Okay. But unfortunately, you still have probate. So we don't want probate. We don't want to rely on this. So probate, bad. Because it's a court process, it's time consuming, it's costly. But you do get a step up in basis. Okay, so that part's good. With a trust, so if it passes through a trust, like an asset protection trust or a castle trust or a living trust, you do get step up and you avoid probate. So that's a good way to do it. Okay, so trusts are good. Beneficiary designations like a ladybird deed, yes, you get step up and it avoids probate. So that's also. With passing a joint, by adding one of your kids' joint, guess what? No step up. So this is bad. So if you add your kid joint, then it's going back to the original basis that going back to the original basis that the property was purchased at. So we don't want joint ownership. We don't want to lose that step up in basis. So how do we transfer assets without having to pay capital gains upon death? Either through not joint ownership, either through ladybird deeds where you get step up in basis, or through a trust where you get step up in basis and also you avoid probate. If you just leave it in dad's name, dad passes away, you go through probate, you do get step up in basis, but you still have to go through probate, which is a 5-month court process, at least 5-month court process. Plus it's going to be costly. It's going to cost more. So again, how do you want to transfer assets to the next generation or to beneficiaries? You're either going to want beneficiary designations, more specifically that ladybird deed, or you'll want to utilize a trust. Both of those avoid probate. Both of those get step up in basis. So hopefully that was helpful, and that goes for any piece of real estate. So we're not just talking about like your primary residence, that's for other pieces of real estate as well. Or really any non-qualified assets. That's how we want those to transfer. Typically we don't want joint ownership. We want it to go through either beneficiary designations or trusts. And it just depends on what your goals are, which one makes the most sense. For a majority of our clients, we do go the trust route at the end of the day, where it flows through a trust because you can build on some additional benefits. But we don't want joint ownership, so don't name the kids joint to the pieces of real estate or really any other accounts, and we don't want probate. Okay. So questions coming in here, if the value goes down, you're still not going to have any capital gains issues. So if so in this situation, if that 350,000 value is now like 250,000, you wouldn't have any capital gains. In fact, you might have a capital loss that could show up potentially. Someone raised their hand. So if you can just type in whatever the question is, that would be helpful. I haven't figured out how to like allow people to talk and stuff like that. My Zoom skills aren't that good. So if you can just type in what that question is, that would be good. I'll give you a second to type it in. Also, another problem with, and just maybe while you're typing that in, if another problem with joint ownership, so it's a double bad, is that by naming your kids joint or someone joint, you're opening yourself to all the liability. So there's liability issues too, because now, and I've seen this, if you name someone joint to a piece of real estate, and I had this happen, mom had named her daughter joint on a piece of her home, and then the daughter actually needed long-term care in a nursing home, and Medicaid was going to say that this property that was mom's, that mom had named daughter on jointly, was a countable asset and wanted daughter to sell the house before she qualified for Medicaid. So again, joint ownership is really bad. Like we almost never recommend naming someone joints to a piece of real estate other than a spouse or especially the kids. A question here coming in, if there is a loss, can it be used to reduce overall capital gains for a tax year? I'm not a CPA, but yeah, my understanding would be if you're showing a capital loss of $50,000, that could offset any capital gains. So I don't see why you wouldn't be able to do that. Another question coming in, is a quit claim deed the same as a ladybird? So there's a quit claim deed. There's two types of deeds. There's either what's called a quit claim deed. So it's quit, not quick, quit, versus warranty deeds. These are technically the only deeds that get recorded. And it's either a quit claim deed or a warranty deed. So there's different types of quit claim deeds and there's different types of warranty deeds. But really what this is an enhanced life estate deed. And that could be a quit claim deed or that could be a warranty deed. The difference is really just whether you're warranting that you're the true owner and that you've paid all your back taxes on it. Typically, when we're just transferring it to the trust or something like that, we'll do a quit claim deed. What this is not is the old deed in the drawer trick. Okay, and I still see this done, and I don't know why. Basically, what you're doing is you're signing a deed, but you're not recording it at the county. There's lots of problems with this. A, the deed could be lost. Now you end up in probate. B, when you file that deed, technically you're supposed to notify the property transfer or the property assessor that a transfer has been made. And if you haven't, they can penalize you for back property taxes. And then C, technically when you sign the deed, that's when the transfer happens. And so basically you've already transferred it to the kid. So it's now the kid's house, even if it's not necessarily recorded. And that can create some liability issues as well. So sometimes I see people use the word quit claim deed with the idea that it's this deed in the drawer trick that will sign a deed. And then when I die, the kids will go record it. There's only downsides for that. There's no upside. So if that's the case, I would just use an actual ladybird deed, which is a deed that's signed right away. It's recorded at the county. We send a property transfer affidavit, notify the tax assessor that a transfer's been made, but it's an exempt transfer, so it doesn't encap any property taxes. Okay. If I decline the Michigan PIT extra coverage, okay, all right, we'll talk about that. All right, so that is it on deeds and real estate. Okay, second question here. And this is I've actually had this asked a few times, so it's good that it was asked for this. So with the Secure Act 2.0, when do I have to take out my required minimum distributions? RMDs, required minimum distributions, this is when you have to take money out of your IRAs, out of your 401ks, out of your 403Bs, et cetera. And these are all pre-tax accounts. So I'm not talking about like your Roths or anything like that. These are all pre-tax accounts. And so when do you have to take out, and the government forces you to take money out because the government wants you to defer as long as possible, because the more you defer, the more you grow a tax bill. You don't actually grow more money for you, you grow a tax bill. And for example, sometimes I get pushback on this, but let's say you have $100,000 inside of an IRA. Let's assume a 20% tax. And let's assume, just to keep things simple, let's say that we move the money, we do a Roth conversion. Now we're left with $80,000, okay? Now, let's say they're invested in the same thing. So both of these go up 10%. They're both in XYZ mutual fund or XYZ exchange traded fund. So both of these go up 10%, and you're like, well, see, Chris, that's great because this is going up 10,000, that's going up 8,000. I want my money to grow in a tax deferred account because it's a bigger number, right? Well, what's the problem? We always have to pay tax. It's just a matter of when. So assuming we still have a 20% tax, whoops, let me take one step back. So if we add on that 10,000, now we're at $110,000, which looks great. Here we're at $88,000. But we still have to pay that tax. And let's assume taxes remain the same, which we know taxes are going up. So if we take a 20% tax, well, now we're paying $22,000. So what does that leave us? Oh, well, that actually leaves us $88,000. So by deferring paying the tax, it's not like our money is growing because it's compounding interest. All we're doing is we're actually growing the tax we pay. So if we defer, all things being equal, we're paying $22,000 tax versus if we pay the tax all at once, $20,000 tax, or pay the tax up front. At the end of the day, what you're walking away with is the same, but the government wants you to defer paying taxes as long as possible because you're growing a tax bill for them. Okay, they appreciate that. Now, the thing is, we know taxes are going up in the future. So what if this is, say, 30%? Like now you have even less money at the end of the day. But yeah, so the government's going to force you to take money out of the pre-tax IRAs. And prior to 2019, the number was 70.5, which is kind of a silly number because who knows their half birthday? Most people don't know their half birthday, okay? But what happened when Secure Act 1.0 was passed, and this was in December of 2019, now we're pushing back the RMD age to 72. Okay. Well, that's great. At least that's a round number. People know when they turn 72. But then Secure Act 2.0 came along. Okay. And this was, what was it, 2022? And it pushed it back to 73 or 75. So again, it's creating confusion. It's kind of silly, but here's a way to think about it is just based on your age. So if you're born in 1950, you're taking it out at 72. If you're born at 1951 to 1951 to 1959, you're going to take it out at 73, and then 1960 or later, you're going to take it out at 75. So this is just a simple way to understand the RMDs. The way they worded it is super confusing, but just use that as a rule of thumb. Whatever year you're born in, if you're born in 50, you're taking it out in 72. If you're born in 51 through 59, you're taking it out in 73. If you're born in 1960 or later, then you're going to have to take money out at 75. But here's the thing, I would not be waiting until my RMDs to look at having an IRA exit strategy. If you think taxes are going up now, or you think taxes are going up in the future, I'd start pulling money out of these pre-tax accounts sooner rather than later. Have some type of IRA exit strategy. I think taxes are one of the biggest risks and biggest opportunities out there. All right, so that is RMDs, required minimum distributions. If you have a Roth, no RMD. Now with the kids inheriting or any beneficiaries inheriting it other than a spouse, they have to take all the money out within 10 years, okay? So even if it's a Roth, they have to take money out over 10 years when they inherit it. There's a difference between an inherited IRA. Here's a question. How would a 401k that is 70% pre-tax be treated if you convert it to Roth? Are you able to separate the two pots of money within the 401k? So this is just continuing on, kind of on this question. So let's say we have a 401k and 70% is pre-tax, 30% is Roth. How could you move it over to the Roth? Well, first, what you could do is see if your plan sponsor, your employer sponsored plan, allows you to do a Roth conversion within the 401k. Typically, what we see is that people will take these two pots of money, and so this is this is Roth. We would roll this over into two different accounts. Okay, so now we would have a traditional IRA that's not at the employer-sponsored plan. This would be the pre-tax account. And then we would have the Roth IRA, individual retirement account, that's the tax-free account. And then what we would do is, in an intelligent manner, look at doing Roth conversions from the IRA to the Roth IRA. And we would look at your tax brackets to figure out how much we should do in each year. You can see if your employer will allow you to do a Roth 401k or a Roth conversion inside of your 401k, but it's going to depend on the plan administrator. Typically, the way that we see it done most often is we roll both of those accounts out, one to a traditional IRA, one to a Roth IRA, and then we do the conversions from there. Okay. All right, moving on. All right, if I have a financial power of attorney for mom's checking and she passes, can I liquidate it or does it go to probate? Should I be the joint owner? Okay, so we have this, we have a checking or savings, really anything at the bank. One of the things that we would recommend, so if you have this financial power of attorney, a lot of people don't understand this, but that financial power of attorney upon death goes away, okay? So the financial power of attorney, the medical powers of attorney upon death, those end. Those are only for incapacity. If someone passes away, those ends, you cannot utilize those. Those are only for when people are living. So your financial power of attorney, your medical power of attorney, that controls who can make decisions while you're alive. Upon death, those are done, okay? So with that power of attorney, you would not be able to liquidate mom's checking or savings account upon death. So then we get into, and we've talked about this before, just plain estate administration. How do assets transfer upon death? And I just talked about it, but there's only 4 ways. One would be joint ownership. Okay, so yeah, you could name yourself joints, or you could be named joint on the checking account. That would avoid probate. Second would be through a beneficiary designation. Okay, beneficiary designation. And for checking and savings, typically at the bank, they'll call these either transfer on death or payable on death. TOD, POD, they mean the same thing. It's just a beneficiary designation. So it's in mom's name while she's alive. Upon death, it goes to you or goes to whoever it was supposed to go to. Third would be through a trust. So the trust could be the owner of the checking savings account. The trust could be the beneficiary of the checking and savings account. But if it doesn't go through one of the first 3, then it ends up going into probate. And that's what we want to try to avoid. So we don't want probate. And also keep in mind, a will does not avoid probate. All a will does is gives instructions to the probate court. And for reasons I shared before, I don't recommend joint ownership typically, because if you name if you're named joint on mom's checking, savings account, real estate, you're opening yourself up to, or mom is opening herself up to all of your potential liabilities. You get a divorce, lawsuit, creditor action, bankruptcy, you might need long-term care yourself. So typically what we recommend is a combination of things, of having the financial power of attorney. So this is to be able to pay mom's bills while living, and then either have a trust or beneficiary designations to make sure it avoids probate, goes where it's supposed to upon death. So having the financial power of attorney while mom's alive to be able to pay bills, and then either having a trust or beneficiary designations, make sure it avoids probate and the checking or savings account goes wherever it's supposed to go. And this is a great question, because we see a lot of people in terms of their estate planning forgetting to do payable on death or transfer on death, adding beneficiaries to their checking savings account. Almost everyone adds beneficiaries to their life insurance, their 401ks, the IRAs. But we see a lot of people forget about the house. We see a lot of people forget about their checking and savings account, bank accounts. So that's something I recommend everyone to run out and do. It's very easy. Just check to make sure you have beneficiaries listed on every single checking savings account. And it's also a good reason why that we should be consolidating these things. We don't necessarily have to have 10 different checking accounts. Okay. And then here's another question that just came in. And if you do have any more questions, feel free to put in the Q&A. This is the last one that came in. With the decline in the Michigan kind of auto coverage, are my assets safe in a trust? So the question is, with the recent auto change and changes in liability in Michigan, are the assets safe if it's in a trust and it's a CW structured trust? So really the answer to this question is, what type of trust? So what type of trust do you have? In this situation, I know kind of what type of trust do you have? The answer is yes, but really there's two types of trust. There's what's called a revocable living trust. Okay, revocable living trust does not protect you against two potential catastrophes. One would be lawsuits. The other is the long-term care costs, which can run $10,000 to $15,000 per month. Okay, so revocable living trust does not protect you against those things. So the answer in that situation would be no. Okay, but if we have an asset protection trust, we call it a castle trust, and we have our assets inside of the trust, then everything is protected from the lawsuits, everything is protected from the long-term care costs. So hopefully that's helpful. So yeah, if there's any concerns about liability, getting in a car accident, things like that, with an asset protection trust, so our castle trust, the answer is yes, you are protected for whatever's in the trust. If it's a basic revocable trust, the answer is no. All right, and let's see. Is a recording of this presentation available? I didn't get to your event notification in time. The answer is yes. So these are all recorded. They're live on our YouTube channel. So if you go to Castle Wealth Group Legal YouTube, or type into YouTube Castle Wealth Group Legal, then we'll go ahead and pop up somewhere in there, and all of our previous recordings are there. Plus we take a lot of the individual questions that people submit, and we turn that into individual little kind of bite-sized educational pieces. So yes, these are all recorded. And if there's anyone that you think would benefit from attending one of these, please share the information. Just go to wisdomwebinar.com and you can go ahead and register. We do these about once a week. We really enjoy just connecting with clients and the public to really just answer whatever questions you have. This really is for you. So with that, that is all I have. Any last questions, feel free to put it in. Looking at next week, we should be good to go on Wednesday. We'll be closed Monday and Tuesday for the holidays, but we'll be back in the office Wednesday, so we'll be back on the webinar Wednesday. So with that, thank you, everyone. Make it a great week. Take care. Bye-bye. Thank you. You're welcome.